Good day and welcome to our fifth episode of the Constitution of American Life, the summer episodes, as we address the principle of rights, those found in the Bill of Rights and not, and some of the current issues dealing with rights. Well, the dog days of summer have definitely arrived here in the Central Valley of California as we're playing around with 106 degrees. And of course, if you follow the news, Yosemite and possibly the giant sequoias are in danger from another California wildfire. I do hope that the conditions in the hometowns of my colleagues are a little bit more pleasant than they are here right now. We also have a birthday to celebrate as Dr. Williams got 1 year closer to being contacted by the AARP. I know that's hard to believe given his baby-faced good looks and his agile, athletic demeanor, but his mind has slowed in the last couple of years, which is evident of these programs if you watch. Well, from informal surveys taken over the years as an educator, there is not a topic more appealing to the young than the topic of rights. That reinforces the ongoing trend over the past 70 years of America being a very rights-conscious culture. That is not to say that rights haven't always been important to Americans, but I can say without any reservations that Americans in the 20th century and 21st century have become obsessed with rights while simultaneously forgetting about the flip side of the coin, and that is responsibility. It is important to remind our students and our listeners that, in my humble opinion, the key principle underlying our constitutional system is balance. Balance between the branches of government, balance between the state and national governments, and balance between individual rights and common good. So as we discuss the rights found in the First Amendment, such as speech, press, religion, assembly, and of course others, as well as the rights of the accused found in the Fourth, Fifth, Sixth, and Eighth Amendments, that we keep in mind the need for balance. And so let's begin our discussion today with the belated birthday boy here, Professor Mike Williams from the University of San Diego. Mike, internationally, and this is more of a political science thing, I think, but again, I'm not the brightest guy in this group. Internationally, rights can be broken down to two categories: positive rights and negative rights. The American tradition has been a reliance upon negative rights. And in fact, a larger descriptive term for our Constitution is negative constitutionalism. Why is that? And I have a follow-up to that. We'll start at why is it that America stands out as a prime example of negative rights, whereas it seems much more of the democratic world has turned towards positive rights?
Yeah, that's a really good question. And given the fact that the United States was one of the first, if not the first country in the world to experiment with democracy and classical liberalism, at the time in the 1700s, this was the nature of rights, the conception that was out there that was being discussed was one that was negative. And it was one where what political thinkers were concerned about was a government taking away something that you naturally had, right? So a negative right, what it means is it just means that the government can't take something away from you. So we articulate those in the Bill of Rights and other places in the Constitution. There are things the government can't do to us. And we see that. That's our articulation of what it means to be free, what it means to have liberty. This wasn't the only way that people were thinking about freedom and liberty. You know, we can talk about classical Republicans and the way that they thought you actually become free by participating in government or being part of a collective. But that was not the dominant sort of narrative in the United States. So it's based on history. It's based on when we were founded, and it's evolved. I mean, it's changed over the last 240 years, as you might expect it would have. But I think that most Americans are comfortable with the conception that freedom means that government should pretty much leave us alone in some of our basic rights.
Well, and, you know, so you said it's about history, it's about, you know, and obviously it's about culture of 18th century America. But given the myriad of dynamic changes just in culture And then also we can look over the past 230 years or so of history. Do you think that technology or technological change, the growth of the population, just the very nature of how we live would now demand that we somehow articulate or enumerate more positive rights?
Yes, I do. But I don't know if it's, I mean, I see where you're going with technology. I see it more as, again, like I just said, if you assume that the greatest fear is that government is going to take away your rights and to be free is to be left alone, then you probably wouldn't have any need for positive rights. But in a society like today, in a world like today with globalization, where there's massive inequalities, I think we really have to ask ourselves, does a person who has the right to freedom of speech, for example, but doesn't have the means at all to participate in those debates, is that really freedom? And should we be conceptualizing more positive types of rights in terms of giving people access to the tools they need to be active participants in a democracy?
Mr. Tim, go ahead, Tim.
Yeah, Mike's point's important about the history. I can't help but think our founders' obsession with negative liberty, I would suggest in large part has to do with their experience with a government that had carte blanche plenary power. And so that historical, to Mike's point, the historical moment is our founders lived with a government, England, Parliament, that had total power. So I think it's very predictable that they glom onto Locke and Hobbes because they clearly articulate that these governments should be minimal so rights can be maximal. So I think the background of plenary power really drove the negative liberty principles in the founders.
Our friend Sue Leeson, who for the folks that will watch this, Sue is one of the co-authors of the textbook of the We the People textbook and very involved in the program, former Oregon State Supreme Court Justice. And she said this years ago, and it stuck with me, that she described rights as, especially the Bill of Rights, think of it as shields or swords. You have a shield as a barrier from the government, a negative right, requiring perhaps a valid warrant to protect you in your home, versus you have the right to an attorney. So here's a sword you can poke the government with. I have the right to an attorney, as you find in the Sixth Amendment. And Mike, to push back just a little bit, and this is going to be out of character for me, but no, seriously, because I'm going to take a stance that you talked about the inequalities in society, and perhaps people have bigger megaphones, right? Is that, what you're talking about, your example of freedom of speech, but does that mean that we should say if someone has the ability to have some type of online presence, do we need to limit that so other people can have an online presence?
I don't think it's about limiting it. I think it's about making sure that there is equal access to the platforms.
Okay.
And maybe freedom of speech is maybe that's not the best right to kind of think about this, but there are all sorts of positive rights out there that other countries experiment with, and a right, we've talked about right to housing, a right to clean water, a right to education. And the notion is, if all you're doing on day to day is simply surviving, right? And how can you be an active member in the country? And then are you really free if you can't, right? Then who else is going to step in and do that?
Right.
Can I interject a psychological observation? Mike's comments about, what good is right A if you don't have certain other basics. There's a theorist named Maslow, and he postulates that there are certain basic elemental needs that have to be met before other things can occur. So maybe I need a roof before I really am going to care about whether I can vote. I might need a square meal. Now, if those are true statements, then there's an argument to be made for positive liberty, that maybe there should be a commitment of government to meet the lower level Maslow's hierarchy of needs before we can get to these highfalutin things like, speech and association and all these other things. So I think, to your point, David, you brought up technology, and I think that's really good. But I'm also wondering whether there's a psychological component for positive liberty based upon Maslow's theory of hierarchy of needs.
Well, yeah, there's just a basic humanistic, which I think you just addressed from the psychological perspective. And I think it's my understanding, and maybe Mike, you can clarify, that if we look at the rights or the Constitution revolution of post-World War II, where we get this other period of Constitution creation, that almost all these constitutions have positive rights, and that's born out of the cultural, industrial, socioeconomic realities that exist, also the human suffering, that was born out of the World War II period, and that had a great influence on the creation of rights in a more positive sense. Is that an accurate understanding, Mike?
Yeah, no, definitely. I mean, the countries that emerged after the end of the Cold War, in Eastern Europe and Africa and South America, are much more comfortable with the government, the state, playing a much more positive is the wrong word, a much more active role in society, right? And you're right, I think it started with thinking about what universal rights do people have, and how are they fulfilled? And if you don't have access to clean water and food, but you can vote every 2 years and you can say whatever you want and the government will leave you alone, is that really what it means to be free? And what it means to live in a democratic society? And a lot of countries have just answered that and said, no, not quite. Like we need a little bit more. And I think, FDR got close to this when he talked about his 4 freedoms during the Great Depression, right? He was trying to get at this, like, freedom from want is a basic sort of necessity. So,
well, we're a major, player and influencer on the Declaration of Human Rights, and we're obviously a co-signer to that. And there's, that's overwhelmed with positive rights, and that's in, I'm sorry, help me out, 1948 or 1950. I can't remember the year in which the Declaration of Human Rights comes about.
48.
But so I mean, that predates the end of the Cold War, so we're already thinking about positive rights long before those countries in the end of the Cold War there. So Tim, I know this seems like a simple question, but it's one that came up a lot when I taught, and kids would ask is, do majorities need bills of rights? Do they need enumerated rights? If you have a Republican government that's based upon the rule of the majority, so what's the purpose? That is, let me add it. Don't bills of rights put too much of a barrier on majority rule?
Well, I suppose my glib answer is that's why bills of rights are there, because of tyrannical majorities. I think, wow, that is a curveball. Well, I don't. My gut reaction is no. Largely because Madison was scared to death of the tyranny of majorities, and what majorities were doing in state legislatures. So if they have control to the policy-making branches, I don't know that they need bills of rights. There needs to be barriers against them, and more. If I could move to the present. I know it's kind of shocking. So I'm way out over my skis here.
First Maslow, and now can I move to the present? 2 things I didn't think I'd hear from you.
Well, there's she reminds me there's room to grow. Hey. So I think when populism can be a scary thing. All right. So when you have populist tirades on the right and you have populist tirades on the left, they don't need they don't need protection. It's everybody that's in their crosshairs that needs protection. So I think the modern, in the last 10 years, I think the rise of pretty noisy and aggressive majorities, I don't think they need a Bill of Rights. That's how I would answer it.
Well, and one thing is, thinking of a Madisonian republic, and I try to convey to kids is that majorities aren't static. And history is not static.
Right.
It's ever changing. And so whereas you may be safely embedded in the majority today, and again, I think I'm living this at this point in my life, who knows about next week? And so when you think about this, you got to understand the fluidity and the change implied, I think, within a constitutional system like ours, and the changing nature of faction and stuff that Madison talked about. That
I'd like to hear Chris and Mike on that. I mean, that's a stumper to me.
Well, I agree with what David was just saying, because the majority fluctuates, and so you're not always going to be in the majority. And I think Justice Jackson, in his one of my favorite opinions, some great poetry almost, in West Virginia v. Barnett, and the whole purpose of a Bill of Rights is to put beyond the power, or I think he uses the word vicissitudes of the majority, to protect the minority from the majority, that majority tyranny that some of our framers and founders were fearful of, because we know in our society that changes. You're going to be in the minority sometime, and you're going to be in the majority sometime. So I think with David's last point, that it is going to fluctuate.
Mike, any insights?
Yeah, I think it's important to have them articulated. I mean, I think I think the kind of country that we have tried to establish is one where people have the freedom to have their moral views, to practice the values that they cherish, right? We want to be in a free country to do that. And so government should allow that sort of room, but you need a frame around it, right? You need some principles that just no one can take away, even if 90% of the population think that you can take it away. And those, I think it's best that they are articulated, or it's just going to be this this moving boundary that is definitely going to be harder to navigate. Now, with that being said, even though they're written down, doesn't make them firm boundaries, as we know, and they have been moving, right? And for some of us, that's the frustration, because we see these as like core constitutional principles that no court or no majority should change. But to live in a society where they're not articulated, that would worry me.
So, Chris, you are famed and consistent throughout all the episodes we've done to reinforce the idea that no right is absolute, which again reinforces my opening about this notion of balance, that I see that as a key theme principle of our system of constantly trying to achieve balance. So, and you can use whatever examples you want to use, but I was wondering, is there a general principle of when we should draw the line on rights, when it is okay to limit those rights?
I'll use, and I really appreciate your opening, David, and we talked about the flip side of the coin, because we talk about my rights all the time in America, but we don't ever anymore talk about my responsibilities. And I thought that was spot on what you said earlier, but I'll just use the phrase that that students will use and teachers will use, and the government and the courts have used, is that the government must have a compelling state interest when it comes to limiting a right. And what does that mean, students? It means they got to have a damn good reason, how do you balance the individual rights versus the common good? And I think there was a quote from Madison that was used in the We the People national questions. It was one of my favorite quotes, and letter he wrote to Jefferson in 1788, and it says, "Melancholy reflection that our rights be exposed to danger whether the government has too much or too little power, and that the line that divides it is so inaccurately defined by experience." So what that means is stuff happens. 9/11 happens. Terrible, terrible tragedy. It wasn't a tragedy; it was a terrorist attack. But what do? Because we're afraid, we're willing to expand government power to keep us safe, which goes back to Hobbes. Very, very much linked to the Hobbesian notion of what do we fear? We fear the violent death at the hands of another. So we're willing to give the government more power so the government can keep us safe. Fast forward to 9/11 and the aftermath of that, and we have the Patriot Act. What happens to rights to privacy? What happens to valid warrants? Those types of things. And so rights are limited. We have to think about that. And you said that, David, no right is absolute. So it's got to be that compelling state interest. Where
Okay.
do we go ahead? I'm sorry.
Well, I want to do an illustration of what's interesting, especially in I think our collective experience with We the People, is that for years, I believe the text tried to stay away from the Second Amendment discussions there, but now it's at the forefront of our national discussion. So using the New York State decision of the court and the Second Amendment, let's just assume for a moment that it is a fundamental right there. What is the compelling state interest? I mean, where do you draw the line on a Second Amendment right?
Sure. I would go back to the Heller decision authored by Scalia, and even Scalia in that decision that he said that there's room for regulation because it says a well-regulated militia, being necessary for the security of free state people's right to keep and bear arms not be infringed. So does that mean I have an individual right to own a firearm? Well, the court has decided yes in DC v. Heller. They decided yes in McDonald v. Chicago when they finally incorporate the Second Amendment. But they also, at least going back to Scalia, understands that there is a need for some type of regulation. Because if I like to go hunting and I'm not a very good shot, can I just get a flamethrower to go after jackrabbits? No.
Kill two birds with one stone, I guess.
Well, I would think so. I mean, yeah, it'd be very convenient because or could I have a chain gun that shoots multiple rounds per second? No, I can't. So there's a compelling state interest to say, Mr. Kavanaugh, you're a fairly stable citizen. You can own a shotgun for hunting. You can own a rifle for hunting, or you can even carry a handgun for protection if you feel you're needed it. But we're going to say, yeah, you got to check the flamethrower or the chain gun at the door. We're not going to let you do that. So there's, as much as I would like to have laser cannons mounted on the grill of my car to blast people out of the way, it's probably not a good idea for me to have those.
Mike or Tim, any thoughts about the general question?
The compelling state interest, there's a conundrum, I'll be generous, because it's the government that's defining the compelling state interest. So to our discussion about Second Amendment, some of my Second Amendment friends kind of look askance at the courts defining what the compelling state interest. I mean, they see it as basic self-dealing. And so I think we have to acknowledge that and that's true of all rights, not just the Second Amendment. But so their response is, we're not quite convinced that the government's made the argument that this limitation on any given right is actually a compelling state interest. So there's always that rub that there's that the government is defining the self-interest of the government. And that their argument is very simple. That's why I have an individual right.
So is this right specifically, I mean, very much a reflection of American culture and American history? Because one thing I found interesting is if we look at kind of, the larger tribe of those countries influenced by England and the French Enlightenment, we look at Australia to a point, New Zealand to a point, Canada, England, obviously a lot. they don't have the same view of the right to bear arms. So is this a right just a peculiar American notion?
It seems to be. Well, I forget which justice it was, and it might have been Berger, a conservative, that I actually said that he was riffing on his ponderings about the Second Amendment. He speculated that the individual right to own a gun is one of the greatest frauds. I think he used the word fraud perpetuated on the American public. So to your point, David, I think Berger saw this as a cultural thing that was going on, and I forget when he said that. Chris or Mike might know that, but I think it is a cultural piece.
Well, but also, Tim, you can help me out with this, because I know in England, the idea of owning weapons or arms, right? Bearing arms. I don't want to jump down this rabbit hole, but if we just talk about that phrase, bearing arms, what that actually means, it's usually in terms of some type of malicious service, right? It's not for the individual protection; it's for malicious service. But in England, they allowed for, I think it was Protestants to be able to have arms, but not the Catholics.
Yep.
Right. We want the Protestants to have the weapons, but not the Catholics. We're going to
give them. And they had a compelling state interest, right?
we're going to give them bingo, but we're not going to give them arms.
Yeah, I think that's a little ham-handed, but
yeah. I grew up. The people watching this, I grew up in the Catholic faith. I was an altar boy, so it's okay for me to make jokes.
Professor Williams, any thoughts on this before we move on?
Yeah, just a quick comment on what I think I heard Tim say about some of his Second Amendment friends. Look, I mean, it's too easy to just say that rights are absolute. It's unworkable, right? Because at the very least, you're going to have two absolute rights that are going to clash. Then what are you going to do? So in any society, in democratic society, there has to be some limitation. And Tim, what I heard you saying, what your friends are saying is, why is it the Supreme Court that gets to decide this? And I think that's a fair criticism maybe just about a larger constitutional question. And I just wanted to raise that some constitutions, like South Africa, have it in their constitution under what circumstances rights can be limited. And they're not letting the courts come up with a doctrine. They're saying, here are the guidelines. And that's just, our Constitution is pretty short on details, right? And for good reason, maybe. But that might be something students to consider. Like, if you're going to have language in the Constitution, when would a right be limited in general? What would that statement be? Like, when would we say it's okay to do that? Under what circumstances?
So, Tim, many Americans, contemporary, but many Americans don't realize that the body of the Constitution has a number of enumerated rights. What were some of those rights, and why did the framers establish these specific rights in the Constitution?
In Article 1, Section 9, there's a whole menu, smorgasbord, so to speak. You've got, there's property protections in Article 1, Section 9. There's habeas corpus, ex post facto, prohibition against bill of attainder. Now, I guess why those things are there, I think I would answer it this way. It's a combination of British experience and colonial experience. I think at Philadelphia, why those make it in the Constitution, because, I mean, as we know, the convention ended without a Bill of Rights, but why these half dozen or so rights are sprinkled throughout the body of the Constitution. I think, in fact, some of the Federalists made the argument why we didn't need a Bill of Rights is because the historically biggies, our experience with Britain, drove us to bills of attainder, drove us to ex post facto, and the great writ habeas corpus. So I think the argument was there's this long British tradition of these are the important things in British history that have gone bad. So therefore, in our national constitution, we're going to put those there.
Well, is it reasonable to argue that those rights are linked, attached to some degree to powers, to
Sure.
specific powers granted to Congress or
Yeah.
the national government? And so with those
Yeah.
powers, we have to have a commensurate right.
Yeah. So, and that, I think that may circle back to what a point I was driving at earlier. It's predictable that they're going to put that in a legislative part of the Constitution because their experience was with a legislature that had plenary power to do whatever it wanted. So I think I think that's a, you know, you're circling back to that idea. It's totally predictable that those would be in our legislative section.
Well, I want to point out something in Article 3 too, which is a jury trial.
Yep.
I mean, that's according to Jack Rakoff, Stanford historian, who I'm sure we've all read a lot of it. The four of us have read some of his work. I would recommend about anything he's written to the students. But he said the two most important rights we got from Magna Carta, or at least the colonists believe they got from Magna Carta, was the right not to be taxed without their consent and the right to a jury trial. And we find that in Article 3. So, I mean, that's not even in the legislative powers listing. That's in the court listing. So that's, you know, that's one of those individual rights that I think is really important as well.
But Tim, I mean, couldn't you argue that the Bill of Rights are also written within legislature, kind of a legislative, you know, dome or whatever? I don't know what visual I want to use here, but, you know, it says Congress shall make no law. So even in the Bill of Rights, they are responding to the legislative power of Congress.
Right.
So why didn't they put those in the body?
Well, I'm going to get a little deconstructive there. I mean, the reason I'm willing to propose the reason Madison says Congress shall make no law is because he wants to get some Federalists to sign on to this thing, and he's trying to keep the anti-Federalists in the camp. So Congress shall make no law. I mean, that phrase, well, first of all, it's ridiculous. But second of all, he's got to somehow ameliorate the fears of anti-Federalists that this Congress is going to run roughshod over the universe. So that's language that is for a political purpose, I believe is important.
Well, also too, David, to help answer that question, is that Madison wanted them in the body. He wanted them distributed throughout the body of the Constitution. I believe it was Roger Sherman that talked him off the ledge.
Yep.
Because, you know, if we put these in the body of the document, it's a new document, and we have to go back through the whole process of.
So you're talking about after the Constitution has been ratified at the first Congress, Madison still wanted to put them in the body?
Yeah, after he got his list, you know, because he's writing this list, and you know, here's a soft-spoken, all 5'1" or 5'2" of him. One of his most adamant speeches in Congress is when they kept blowing him off. He's trying to. It's so funny, David, if we go back to the beginning of your presentation, because we all are about our, you know, as Americans, we're all about our rights. But when Madison's presenting his original draft of the what's going to be called the Bill of Rights, Congress blows him off a couple times because they're dealing with duties and some tax issues. And finally, he gives a speech. It's like, for Madison, I would call it scathing, but you know, it's not what we think of scathing today. And so they ratify in 1791, and you know, he's like, we're going to put them in the body. And Sherman says, no, we can't do that because it's going to change the document. It's going to have to go back for re-ratification. So let's just tack them on the end. And okay, fine, whatever. So that's how it ends up that way.
Well, so, you know, we talked about Madison, and what's interesting, I'm wondering, Chris, my understanding is that Madison initially, after they get out of Philadelphia, the thing's been around, he's opposed to a Bill of Rights.
Yeah.
All right, which I think would shock some people because he's considered the father of so many things. But I know in some exchanges with Jefferson, he reveals some opposition to a Bill of Rights. Is that accurate? And if so, why? And Tim's about ready to come out of his seat there.
Madison is opposed to amendments because he knows full well in his own state, folks like Richard Henry Lee and Grayson have no interest in rights. Well, their interest is not primarily rights amendments. Their interests are structural amendments. So it's a little bit of an overstatement to say that Madison is opposed to a Bill of Rights. He's opposed to amendments that could derail the whole Constitution. So he's suspicious of any anti-federalists who are saying all we want is rights. So he's opposed to amendments. Now, I think in oversimplifying the ratification story, Bill of Rights story, we insert the word Bill of Rights when it should be technically he's opposed to amendments because it would undo everything.
Well, I'm going to push back a little bit too, Tim, because I think he is opposed a little bit to going back in the listing of rights. And Dave, you alluded to the letters, that you can read the letters back and forth between Madison and Jefferson. And, Jefferson finally says, well, I think you guys probably did the best you could, but gosh, I wish I had a Bill of Rights. And little Jimmy's like, I don't think we need one there. And students may run across this term parchment barriers. He's referring to states' bills of rights. He said, you guys have bills of rights at the state, but you don't enforce them. I think there are, I did my master's thesis on this. I've actually looked up a couple of things before on this ratification process. And I would say there are three things that really influenced Madison to change his mind. I'm going to go first with what Tim just alluded to. And he's trying to steal the anti-federalist thunder. He's trying to, okay, you know what? You want rights? Boom, I'm going to do this. And you guys, we're not going to a second convention, because exactly what he was fearful of were structural changes. So we're going to do this. Second is his correspondence with Jefferson. I mean, depending on if people are Jeffersonian or Hamiltonian or Madisonian kind of thinkers, but you can see in the letters back and forth that Jefferson kind of does wear him down a little bit. Finally, Madison, well, really wasn't opposed to rights, but so I think that has an influence on him. And the third thing is he's got to get elected. Patrick Henry was a governor of Virginia, and he is just not like Madison. Devlin is not like Jefferson. He's a machine. The Patrick Henry political machine of Virginia keeps him out of the Senate, because you would think that Madison, being, as you said, the father, right? I would think Franklin was the father of everything, but literally. So he's kept out of the first Senate, and he gets a letter that says, hey, if you want to win the spot in the House of Representatives because your neighbor has got some guy named James Monroe is running, you got to come back and campaign. So he comes back to campaign and promises, if you elect me, I'll champion the cause of a listing of rights. So I think all of those things compel him to undertake what he will call the nauseous project of coming up with this listing of rights.
Well, let's take the philosophical, not the political. And Tim, you've enlightened me. I again, relying probably on some more traditional secondary sources everywhere I go. They talk about Madison being opposed to the Bill of Rights in principle or whatever. So I appreciate that insight there. But let's take the philosophical Madison, not the political Madison. In the end, Chris, especially if we look at how history played out, wouldn't you argue he was right that there wasn't a necessity for a Bill of Rights because the government wasn't granted the power to violate these rights? And again, there is already a right to trial by jury in the body of the Constitution, so we can kind of dismiss that one. But there's no right of Congress to violate freedom of religion. There's no right for Congress to violate.
David, you're making me like I'm gonna have to go with Jefferson on this, and I'm like, I feel like I need to take a shower.
You need to take it. Well, okay, I'm not going to comment on your necessity for a shower, but go ahead.
Well, yeah. Going back to what you said, and for the students watching this, if you check out Madison's notes from the convention, one of the things they thought about putting in the document was protecting freedom of the press. And they argued about this, and they said, well, if we put this in the Constitution, are we believing that we have the power to regulate the press? And so they said, well, we don't. So they left it out. They considered that. But one of the things that Jefferson writes to Madison, and this is a pretty famous line, he says that, a Bill of Rights is what every citizen is entitled to and should not rest on inference as a protection from the government. So I'm gonna say little Jimmy was wrong on that. I'm gonna go with his taller friend, TJ.
Yeah,
If
but
it's,
you
if it's not listed, it could go both ways, David. I mean, you're right. If it's not listed, you could infer that it's not something the government can do. But the anti-federalists say, wait a minute, if it's not listed, that's not automatic. It could go the other way. If it's not listed, that means they could do it.
Well, okay. So with the exception, you two gentlemen who pushed back on Jimmy Madison here.
Thanks
with
for
the
calling, gentlemen.
yeah with the and again, I'm going to grant you that within what 8-9 years or whatever it is, we get the alien sedition laws there, which are problematical when it comes to the First Amendment. But absent those, why therefore isn't there, all right, a single case dealing with the rights in the Bill of Rights other than Barron versus Baltimore, heck, in the first 80 years of our history? And Barron just affirms again the language saying, listen, hey, Mr. Barron, the Bill of Rights only protects you from Congress. It doesn't protect you from the state of Maryland or the city of Baltimore there. So, I mean, I guess that's my angle. If you look how it plays out, Congress is not in the business of violating these rights there. So in that sense, can you give Jimmy a little pat on the back for his opposition? No? Okay, I guess with the blank looks and
well, no, I think I see I understand what you're saying, and because let's face it, and what holds true, when was Barron?
35.
32, 5, somewhere there. Yeah.
Somewhere 1830. And even today in 2022, what level of government do we bump up against all the time? We all bump up against state and local, right? I mean, therein lies the rub.
That's one of Madison's argument, that if you want a Bill of Rights, a list of enumerated rights, then and we know he tried to insert this, they must be to protect you from the state government, because the state government is the most likely government to violate those rights. Yeah.
Well,
all right. So I agree with, I'm all in favor, and Madison would be if these rights apply to the state governments, then yeah.
Well, I think that's what, and Tim, you're going to have to tell me, was it Pickering that used the line, it's like a tub to a whale? Was it Thomas? It Thomas Pickering?
Well, it was Jonathan Swift, and
okay, but I mean, was it Pickering used that to?
I don't know. That could be.
Well, it was the idea that this Bill of Rights is that you've given us is he called it like throwing a tub to a whale. The idea of throwing out a hogshead barrel or tub to distract the whale as it's getting ready to get harpooned back in the whaling days, and the idea that the Bill of Rights or the amendments offered by Madison was merely a distraction from what other folks wanted to do. Back to what Tim alluded to, are these structural amendments, and so the idea was one of the reasons to do this is to head off the anti-federalists at the pass.
And Madison did want a prohibition against the states on in his proposal, and the Senate got rid of that. So, I mean, I can give Madison some props in seeing, I mean, that's if there's one thing that he's worked up about in that window of time, it's state abuses.
That's a great point, Tim, to point out, because he did want the national veto over state laws. He tried to get that in the body of the Constitution and lost in the convention. And then he tried to slip it into his original list of Congress, and he obviously got nixed in the Senate. So you think of, students and teachers watching this, for all 12 of you, if you want to play that what if game, what if the national government had been allowed early on to veto state laws?
So we're going to turn now to some specific, I think, current issues as well as historical. And Professor Williams, I'd like to start off with the First Amendment religion clauses, which have, I think, always been somewhat contentious, but are definitely in the news today. What is how have those two competing clauses, because it's not a singular clause, all right, and the wisdom of of Congress and the framers of the Bill of Rights, they give us the free exercise clause. Congress shall make no law prohibiting the free exercise, But then they also have this establishment clause: Congress shall not establish a religion there. So how has the court, in your opinion, how have they kind of approached this from kind of a historical evolution period point of view? I'm sorry.
I mean, I think it's fair to say that they've tried different methods and different reasoning to get around this. This is a difficult sort of, I think, provision for courts to make sense of, because you're absolutely right. It's demanding, like you said at the beginning. The First Amendment, I would include in there the freedom of speech as well as part of this. This is all about balancing. I mean, we've got to have some balancing going on in the discussion of this. And the court over the years, I think, has moved in different directions on how to best do that balancing. I think, and Tim and Chris, you guys, please check me on this if I'm getting this a little off. From the 1940s, 50s, it seemed like the court was really cautious of making sure the government didn't do anything that looked like it was establishing a religion or advancing one religion over the other. And there was a lot of balancing tests to make sure that didn't happen. The last, I don't know, 10 to 15 years, Dave, maybe that's about right. And we have cases out of this actual term, right? The pendulum definitely seems to be swinging towards this notion of free exercise, and that, the court has said this is discrimination against someone based on their religion to do X and Y. Whereas previous courts would say we have to be super careful about letting the dominant religious beliefs in this country get too close to state action. So I think the pendulum has definitely swung. And right now we're definitely in a time where freedom of exercise of religion is definitely where the court is putting its efforts.
I think a really good way, at least historically, for students to understand, Mike, the tension you describe and the complexity is to do a comparison of Gobitis and then the case that Chris mentioned, West Virginia. What is there, a 3-year window? And they're both dealing with Jehovah's Witnesses and the flag salute. And Gobitis kind of takes a state power and said, yes, we can compel you to salute the flag. And then 3 years later, West Virginia, and we get that poetic language by Justice Jackson overturning Gobitis within a 3-year period. I think that one issue and those two cases is a really good case study to understand the complexity and the competing forces going on there. So, Mike, do you think, just your scholarly, but also, civic response, citizen response to this, you've said over the last 15 years or so, this court is very much leaning towards the free exercise clause. Do you think that the Establishment Clause is dead, at least for the next few decades? Has the court in the most recent decisions pretty much gutted the Establishment Clause and free exercise is going to reign? And that's just not to Mike, if anyone else wants to jump in.
I read.
I think they've redefined establishment to allow for an expansion of free exercise. The book does the We the People text does a pretty good job in kind of giving a historical survey of how establishment has been viewed. So I would direct students directly to the text, because I think how you define establishment directly relates to how broadly you're going to allow free exercise.
Well, Tim, I would agree that there's been a legal argument within law schools about how you interpret that. I don't believe that's been articulated by the court. I think Mike's pretty accurate from the mid 40s all the way until, and I'm trying to remember the case, even O'Connor, and I can't remember the case where O'Connor, and one of the lead cases is Lemon versus Kurtzman, all right, where they give the 3-pronged test there. O'Connor has a little bit of a problem with Lemon, but for 70, 80 years, the court's pretty consistent on this wall of separation. Mm-hmm. And trying to make sure that the state isn't in this situation of endorsing or assisting. So where I agree with you, there's been an intellectual debate within law schools and amongst the theorists of religious liberty. I don't think the court, until fairly recently, all right, and that shows out within that debate, that group has obviously kind of won out, at least at the Supreme Court level. Chris or Mike, thoughts?
Well, I've got an article I just read, yesterday evening, and I'll try and make sure we get it in the listing of references that we post. But one of the statistics they used was that the Roberts Court has sided with the expansion of religious liberty, free exercise, to use, going back to Tim and how he talks about that, 83% of the time. So whenever there's been a question about, well, my rights are limited because I can't use this voucher money to send my kid to this private religious school, and the court has said, yeah, you're right, that's a violation of your free exercise. That has 83% of the time under the Roberts Court. So you see that expansion. And my goodness, we could talk about, I don't want, again, another rabbit hole is abortion, because the whole idea and the debate about when conception begins is the religious feeling that enters into this discussion is overwhelming. So, clearly there's been an expansion of people's rights. And I want to see what happens when you have a coach who is also maybe a practicing Muslim decides to leave a prayer at the 50-yard line after a football game. Will that be protected? Will people that are pagans or Wiccans, will their rights be protected? So we shall see.
Yeah, well, see, the problem is that the coach wants to do that. I'm a civil libertarian, especially when it comes First Amendment. I don't have a problem with that. The problem was it became it became a public gathering. And especially when it comes to schools, that's where things get a little bit dicey, is when suddenly the whole team, members of the team are now out there. Is there a compulsory nature to that, or is there a coercion involved in that kind of thing? But I do wonder, is that, that proverbial wall of separation, and we've debated how high the wall should be, if that wall has been chiseled down to pretty much nothing by this court, or it will continue to be chiseled down to nothing there. So, Tim, I did find it interesting in my prep, and I know I should have always known this, but in reading, it dawned on me that the bulk of the Bill of Rights, all right, the 4th, the 5th, the 6th, and the 8th Amendments, all deal with the rights of accused persons, all right, or the criminal justice system in one way, shape, or form, which seems to give us insight into what they were thinking in the 18th century. So why so much focus on the rights of accused people, given, one, that there's already those rights in the body of the Constitution? So I am curious about that.
Well, again, I think their British history is important, but also I think they're reading a lot of Blackstone in the 1760s. Yesterday and today I was rereading pieces of Blackstone on these particular amendments that you've cited. So I think their experience with their experience in the imperial crisis of the 1760s and their relationship with Parliament. I mean, the writs of assistance starting in 61 through the mid 60s pretty much drives their commitment to what would later be the Fifth Amendment, or excuse me, the Fourth Amendment. About a half a dozen states had all kinds of statements about warrants being not open-ended the way they were in writs. In regards to the Fifth Amendment, remember there's the takings clause, for example. There's all kinds of folks in the Revolution who lost property with no due process at all. And Hamilton himself made a career out of defending loyalists' property interests that were taken during the Revolution. This goes back to, it's rooted in Magna Carta, but their British experience in the 60s, 1760s, their experience in the post-war years, Revolutionary War years, I think drives the takings clause in the Constitution. The Eighth Amendment is interesting. I actually, I don't know, maybe I have a morbid fascination, but Blackstone has some really great one-liners about juries and bail and punishments. I mean, you read it and you think you're I don't know, was it Wes Craven that had all these slasher movies? So they're reading a lot of Blackstone. They know their British history. They know the Star Chamber, where there's no jury. There's no, I mean, you could rot in jail. Blackstone's essay on grand juries. So I think the reason that, to sum this up, their obsession with due process, because again, they're dealing with British history, with a national legislature that has plenary power, and there's plenty of bodies along the side of the road in that story. So that, I think, drives them to include that in our national constitution, to make sure, although it's not a plenary power Congress, but that's their background, their fear of a plenary power legislature.
So
just
go ahead, Chris.
Just an interesting note for the students. This is a much older movie now, Braveheart, with Mel Gibson as William Wallace, a big guy from Scottish history, right? Freedom. If you watch the end of this, and spoiler alert for those of you that may watch it, but it's been out for 30 years now. He's what is he? He's disemboweled.
He's drawn and quartered.
He's stretched, eventually drawn and quartered. That's when they tie you up to 4 horses and they say, giddy up, and they pop you apart and cut your head off. And they've already disemboweled him and they've already stretched him, which means they literally pull all your joints apart. They have provisions, the British had provisions at that time against cruel and unusual punishment. But that was not considered cruel nor unusual. That's how they rolled. And so, that's things change over time. So it's an interesting thought process.
You'd really like to know what was cruel and unusual if that was.
That's a great. So okay, that's a really high bar, right? If you can do that, and that's fine, because that's how we do things back then. What would be cruel and unusual? I don't know. So,
well, I am curious, Mike. You went to law school. Was a lot of your legal training in due process? Or is it that a path you chose if you wanted to in second, third year law? But I'm just wondering how much of your law school training is about these.
There's a required class of criminal law and criminal procedure where these are definitely, and constitutional law. So it was touched on all those. I don't remember specialized classes on due process. There were specialized classes on First Amendment or habeas corpus or things like that. But I wanted to mention just really quickly about the Eighth Amendment. I've been doing, you guys know, I've been doing this research on homelessness a little bit, and talking to some lawyers here in San Diego. There was in San Diego 10 years ago, people were getting cited for sleeping on the streets, right? And there was this case that came down from the Ninth Circuit called Martin v. Boise. And the claim was an Eighth Amendment claim. And the claim was, if you as a city cannot offer someone a place to sleep indoors, you can't cite them for sleeping outdoors. And it was specifically rooted to the Eighth Amendment. So now what has to happen in San Diego is, if you're offered a shelter bed, and you refuse it, you can be cited. But if there are no shelter beds available that night, the police have to let you sleep outdoors at least until 6 a.m. So for me, that was something I hadn't thought about, the Eighth Amendment as applying to an issue that I think in most of our communities, whoever's watching, students, applies. And also I was talking to a lawyer about the Fourth Amendment, and she claims that every time a police officer takes away someone's effects from their tent, that they're violating that person's Fourth Amendment rights, but she cannot get the discovery. I'm going into a lot of details here. She can never get the discovery and get the right evidence to make that constitutional claim. She's working to make that case that there are Fourth Amendment violations happening. I just thought that was another interesting application of this amendment that I hadn't thought about.
Well, that seems to reveal the complexity of the. I mean, we're talking about the First Amendment religious clauses being complex and contentious. The Fourth Amendment has to be one of the squishiest amendments in certain ways by the use of the term unreasonable.
Yeah.
All right, you're protected against unreasonable searches and seizures, and it seems to me the court has had quite a struggle at times on trying to figure that out. And in my opinion, using that term unreasonable really did make the Fourth Amendment a parchment barrier, that it's really no protection whatsoever in regards to Fourth Amendment. Professor Kavanaugh, you agree with me on that? What are your thoughts about this?
Well, I think it goes back
Well,
to
before Chris goes, I'm sorry, something happened here. I think the Eighth Amendment, maybe you talked about this when I was gone, and there was a court case that said there's an evolving standard of decency that should be used.
1972.
Was it Furman, maybe?
Furman.
Yeah.
That there, so that's full of possibilities as to how to Mike's point, and maybe you talked about that when I was gone, but that evolving standard of decency is an interesting way to get to defining cruel and unusual.
Well, Chris was pointing out that draw and quartering at the time under British history was not cruel and unusual, but they did have a prohibition. So we were wondering, what was that? The 14th century, 15th? What would be cruel and unusual if drawn and quartering was not? This kind of stuff.
Blackstone has the slitting of ears, the slitting of nostrils, cutting off of hands and fingers, and I mean it's a really gruesome passage that he goes through the litany of British abuses.
Can I just? I know you had a question for Chris, but I hadn't thought about that Furman case and that language, and given what we've seen coming from the Supreme Court the last couple of years. And even in these recent First Amendment cases where they say we're not going to use the Lemon case, we're going to look at history, right? History and tradition are going to guide our Establishment Clause. The same thing happened with the abortion case, right? And I wonder if this particular court were to get another opportunity to look at that Furman case, whether that notion of evolving standards of decency would hold up with the current interpretive methods the court's using. It's super interesting.
I'm gonna take a pitch on that one. So, I'm gonna go back to the unreasonable search and seizure because Mike, I have all kinds of things to say about the current court, but I won't. And the idea of something being unreasonable, as in the Fourth Amendment, you're protected from unreasonable searches and seizures, goes back to Tim's point about compelling state interest, because now. The government gets to decide the compelling state interest. Now the government gets to decide the unreasonableness of the search or seizure. So absolutely, David, going back to your point.
I've always wondered why they insert the term unreasonable. All right. No search or seizure without a warrant. Well,
because they put it because knowing full well that, the authorities will need to search. They need to be able to search. They know that there are people will do things that will be, illegal or corrupt or bad. And so the government will need to be able to search. But if you put it right next to the writs of assistance and general warrants, I think Tim alluded to that earlier too. When you have these writs that allows the king's men, whether it be customs officials to search any place, anytime for anything or anyone. Was it Olmsted? Maybe in Olmsted they said that was the major reason for the American Revolution. Was that Olmsted was a search and seizure case the court heard years ago. So I think that knowing full well that there should be searches, but we're gonna, we're gonna put it out. This is what has to happen for the search to be legitimate.
And would you agree with me though that the term unreasonable has given tremendous latitude to the government?
Oh, well, I'm going to hold this up as a prop. I do this in class all the time. So we all carry around these supercomputers in our pockets or whatever. Most of us do. And we're still deciding whether or not the government can hack into this based on something that was ratified in 1791. You know, so it's kind of crazy that the word unreasonable and the whole Fourth Amendment is still in play given what we have today. So
Well, that transitions to my question to Mike, and technology and the Fourth Amendment. Again, this unreasonable standard, all right, of searches without warrants and stuff. It seems that we, the people, I think, Chris just articulated that, and the courts are having a real difficult time on ascertaining the technological aspect to the Fourth Amendment on search and seizure. Do you agree?
Oh, I completely agree. And I think it's, with the technology piece, to me, it's a combination of the amendment itself and then just sort of cultural norms. It's just super interesting, the rights that Americans get super vigilant about and the ones that we kind of just consent to, like, it just doesn't matter. And to me, it points to we are consumer citizens more than we are democratic citizens in most of our thinking. So Chris's point, right? Like, we consent to what happens to our data to the extent that we accept and don't read what's there. That's what's most scary, I think, is that we are just sort of we want the convenience more than we're worried about the consequences of what's going to happen with the data.
I just want to play Texas Hold'em, right? So I'm going to sign off on anything.
Right.
But the government should not be able to crack my phone. But the people whose ever app Texas Hold'em I use, they whatever. I'm good with that.
I like that term, consumer constitutionalism, or whatever it was there, Mike. So I'd like to spend our time talking about, again, an issue that's very much in the news and one that's always confounded me. And that is the Ninth Amendment and the notion of unenumerated rights, which is, by the way, it's in the Constitution, people. All right. It is the Ninth Amendment. It's very clear. Understanding as best as I do the history and the discussion and the reasoning behind it. To my knowledge, it's never been where it stood out by itself and was referenced. It's been included as one of a package deal of rights. And I do have to let you know, gentlemen, that I spent a lot of time reading Akhil Amar on the Ninth Amendment, which was interesting to a certain degree there. So I'm going to throw this out, and whoever wants to jump on it first. So first of all, how do you understand enumerated rights and its place in our constitutional system? Is it just a throwaway statement to appease, all right, the forces in the ratification of the Bill of Rights debate, or does it have, in your meaning, real historical, tangible meaning in our system of government? Maybe that's best to start off with you, Tim.
I'm not enamored with the Ninth Amendment. I see it more as to your observation, David. It was kind of I see it as a ploy to get the anti-federalists or actually the federalists on board with this, because that was their original argument. We don't need to enumerate them all, or if we did, we might miss some. But there is, I think, a good argument to be made that there's a connection between the Ninth Amendment and actually the Declaration. Remember, Jefferson said, among these are life, liberty, and pursuit of happiness. He said among. So I guess my argument, and I think I kind of believe this, I don't really want to, but I think I have to. If Jefferson said there are other rights other than the three I've listed here in the Declaration, maybe the Ninth Amendment is the 15-year later statement, consistent with the Declaration of Independence. I'm also going to make the argument that maybe the 14th Amendment Privilege and Immunities Clause is another restatement of.
We're having problems there, Tim, with you freezing up.
Among these are the Ninth Amendment. So I think in our history, I think a conceptual chain of there are more rights than we have that are listed.
Chris?
Oh, I agree. I was getting ready to call Tim out and see, well, if the Ninth Amendment is an appeasement to the Federalists, so is the 10th Amendment an appeasement to the Anti-Federalists? And should we just like kind of brush that aside, like everybody's brushed aside the Ninth Amendment? And thank you so much for bringing up the Privileges or Immunities Clause, which you find in the Constitution, in the body of the Constitution, as well as in the 14th Amendment. So I think that's imperative to take a look at that. Think about this now. I'm going to throw in a contemporary issue that obviously with the recent ruling out of the abortion case, now you see states trying to limit travel for people. And I think that there's going to be a case to be made for the privileges or immunities of citizenship, which is the ability to travel freely, which we've never really concerned ourselves with a whole bunch because we're a bunch of white guys. Had we been people of color, we might have had to concern ourselves with that freedom of travel. But I think that we may be coming back to that.
Well, didn't the court articulate in the 1890s or so a right to travel?
Yes, it did.
Not under the privileges and immunities. I mean, how did they articulate where was the right to travel found? Where do we find that? Because there's no enumerated right to travel.
I think that goes back, was it Article 4 is the Privileges or Immunities Clause, and Article 4 as well as the 14th Amendment. So I think it's grounded in that, David.
Oh, I thought the Privileges and Immunities Clause was kind of in the 14th Amendment was gutted, by Slaughterhouse.
Yeah, but our Article 4 of the Constitution has the same clause, right? So your ability to travel as a citizen, freely travel as a citizen, which again, I think that, I just said this recently that we need to bring back the Privileges or Immunities Clause. I think and therein is a link to the Ninth Amendment, as Tim alluded to, because we know that, well, I always call the Ninth Amendment our safety net. We're going to list 1 through 8. We've got these listing of rights, this enumeration of rights, which we're going to argue about continually, and the courts will interpret different ways. But you know what? We can't list everything. So we're going to put a safety net in and say, you know what? Yeah, we've listed these things in 1 through 8. Doesn't mean you don't have others. We just haven't figured out what they are yet.
So even though it may be a throwaway,
It's not a throwaway. It's not a throwaway.
The 9th and 10th are throwaways for political purposes. Even though it might be, that's a possibility, it's still written, and therefore it still has to have a constitutional meaning.
Well, if it's written, it's not a throwaway. Because if you're going to say it's written, then let's just throw out everything. Sorry to swear.
Well, I guess I don't want to go down that rabbit hole, but it seems to me didn't the court at one time articulate pretty much the irrelevancy of the 10th Amendment by saying that it was redundant, that it was a truism, and that it really didn't have much meaning because the idea of the 10th Amendment was already articulated in Article 1, Section 8, 9, and 10 there. And so Article 10 of the Bill of Rights was not saying anything different. Whereas Article 9 or Amendment 9 is, I think, saying something different. And I think Tim has, and you guys have a good thought, that the Declaration as well as the Privileges and Immunities Clause there. I guess the follow-up question, Dr. Williams, is, so how do we enumerate unenumerated rights?
I'm glad you asked Mike that.
Take that one, Mike.
I've been waiting for this one all night. This is the easy one. Come on. All right.
Well, in the Dobbs decision, all right, this term's decision on reproductive rights, in the Dobbs decision, Alito does give us some guidance on how we would enumerate unenumerated rights. And so, okay, I'm just wondering your thoughts.
Here's my taking my stab on this. So at the time of the writing of these words, right, the founders had in mind classical republicanism and classical liberalism. And republicanism is this idea of continual sort of like civic participation and an ongoing dialogue about the kind of society we want to live in. So I want to read into the Ninth Amendment that that's the opportunity for us to have a continual dialogue about what those rights are that are retained by us, the people. not the citizens, but the people is what the words are, right? So personally, I'll just show my cards. I like that because I want the Constitution to be more living than just a document from the 1780s. That personally, I like that. What worries me though about imagining a dialogue in our society right now about what rights we would want to retain, how do we then protect the minorities who are going to be maybe threatened by those articulations? Is that just an invitation for different generations to declare their own values to be dominant in a way that would hurt others? But I do see it as an invitation to dialogue, but it's
an invitation to, I mean, again, the idea of unenumerated rights means, okay, we listed some, we didn't list, you know, every single one, and we're going to leave it up to each generation, all right, to articulate if they find a need to, but Mike, it's to expand rights. Unenumerated rights doctrine does not mean that we're going to give power to some future generation to take rights away or to take rights away. Doesn't that make sense?
Well, but that's the dilemma, I think, of a living constitution where you have courts in charge of interpreting the words. I mean, you and I over the years, Dave, have talked about this a lot, that the arc of our history, I think we want it to be a history of expanding rights or finding new rights, expansion. But I'm willing to suggest that there can be, if it's living, you could contract the interpretations of rights or how far they go or how far they don't go. So the dilemma for me is a living constitution. It's not a default expansion of rights. It could be a contraction. I think that maybe ties into Mike's point.
Chris, do you agree with that analysis by Professor?
Well, I do agree. If you're going to have, like, I think of the universe as constantly expanding and contracting. Universes, I mean, with the new telescope we have out in space and the images that we're just getting back at this moment, they're fantastic. It's incredible. I don't understand the science, but it's incredible. So if there's an expansion, you have a contraction. But what worries me is the fact now we have a Supreme Court that is representative of the minority of people in this country. And I don't want to go on my usual rant, which is the whole idea that the Constitution has a lot of flaws, or we have a lot of flaws. But so you have a current court with the Dobbs decision that has constricted a right, but that the current court represents a minority of the people in this country, which is it's alarming. It really is alarming to me as an individual.
Well, and that's what I found fascinating about Amar's analysis of the Ninth Amendment. It seems like his guideline is, and again, he argues that the unenumerated rights doctrine is only for the expansion of right. It's not for the contraction. That if we want to contract, we have an amendment process to do that. But the founding principles is all about natural rights and expanding those rights according, if I understand Amar correctly. But where I got a little bit unease, felt some unease with his analysis is he seemed to fall back on and again, he was using the same language to a certain degree as Alito, tradition, history, yada, yada, yada. But his primary thing is if it's popular with the people, all right? And so if something's popular with the people, then using unenumerated rights doctrine by courts is perfectly legitimate. Now, and I was reading an interview of him, and the interviewer said, well, what about Brown versus Board? He said, well, Brown versus Board isn't unenumerated. It's specifically said in the 14th Amendment. That's why it doesn't have the same issue. And I did find it interesting. He brought up some other issues, like the idea of your ability to take the stand in a criminal case against you. He said, that's not enumerated. That's an unenumerated right that's very popular, and no state wants to take that away. The right to the appointment of counsel, all right, that we get, I believe, from Gideon is not enumerated in the Sixth Amendment. it's an unenumerated right, but it's popular and no state wants to retract that. And it's interesting, he says the right to privacy for contraception is an unenumerated right, which is very popular today kind of thing. And so, so that seems to be his guideline. Where Alito's, it seems to be that it's we can enumerate an unenumerated right if we find that right in the tradition of 1789 or 1868, which is a little bit more, narrowly tailored than the professor's is. Any other thoughts about that?
I've got to pick apart some of that, because we have to talk about incorporation. You mentioned Gideon. I mean, the Sixth Amendment tells you have the right to counsel, right? And that's one of those swords I mentioned early on. You have the right to counsel. And what we get through Gideon is the incorporation of that right to protect you from state governments. Because David, back to your point about Barron, thanks to the great Chief Justice Marshall, Barron says that, the Bill of Rights only protects you from the national government, not from state governments. But through the 14th Amendment, through the incorporation clause, those rights have now protected us from state governments. So I would argue that is an enumerated right. However, when you talk about reproductive services, the right to privacy, the right to reproductive health, those aren't nearly as clear cut as, say, the right to counsel and the incorporation of that.
And that's his point. If it's not clear cut and it's not, that there's no tradition, like he says, if you look at the appointment of counsel, the majority of states at that time of Gideon already did allow for the appointment of counsel. Florida didn't, but a majority of states did. So he said there's an an overwhelming groundswell of support of that idea. And he says the problem with Roe and the problem with privacy for reproductive freedom is that there's not an overwhelming groundswell, all right, of state support for that. And therefore, now he, again, on the flip side, he says contraception, privacy with contraception, is, overwhelming. And he says the only state at the time of Griswold was Connecticut. Every other state allowed for privacy and contraception at the time. And so I guess my final, I'll ask, does Congress have the right to enumerate an unenumerated right?
Congress doesn't have rights. Congress has power.
Does Congress have the power? Thank you. I appreciate that. No, I do. But does Congress have the power to enumerate an unenumerated right?
Well, I think they did in the Wagner Act, the right of union association. So I think now I might be playing fast and loose with statutory law there, but I think there's an argument to be made that they did in the Wagner Act create this right of association for unions.
Because that seems to be a lot of in the discussion is, okay, Congress needs to, codify the right to reproductive. And I'm kind of going, okay, if they do, what's their source of authority in the Constitution to do so?
Right.
Well,
Right?
that's
Go ahead, Mike.
well, that's the first part, right? Yeah. Do they have the power to do it? And then if it's something that's passed by law, then I just think we've kind of turned into a parliamentary government where the next majority can just then take it away. So that's the kind of, it's not going to be as secure as finding it in the Constitution, obviously.
Right.
So I just want to check. I want to check in with you, Mike. So are you saying that to enumerate an unenumerated right, that's only the power of the courts or amendments?
No, I think I've been thinking about this because I've been hearing the same thing, and I've been thinking, okay, what enumerated power would Congress claim to pass a law to legalize abortion? And that's the first step. The second step is 2 years from now, when there's a new Congress and a new president, whatever, would it just get flipped around anyways? And so, yeah.
So Chris, you were going to say.
No, I was just thinking of our friend, Dr. Adler. He's one of the things he always says, the power to make includes the power to unmake. So that's to Michael's point. So if Congress has this ability, this power to say, we're going to list a right, whether going back to Tim's great example, the Wagner Act, or to a more modern example that people are calling for, this codification of the right to reproductive services. All that means is when there's a new Congress, which could be as early as 2024, then they can change it then.
Yeah.
So as we've built a tradition in closing our programs, I've asked you gentlemen to give some advice, some insights, maybe ways that to have students and teachers think about Unit 5 here as we get ready to close our program. So Professor Kavanaugh, what insights, recommendations might you give as students go through Unit 5?
Well, obviously the students, it's just the amount of case law is incredible, and it never stops, nor should it, right? So it just shows you that we think that laws or rights are settled, and they're not. And when the court changes, going back, David, to your point about West Virginia v. Barnett and the Gobitis case that was in 1940, and think about that rapid change. But what changes? You got a membership in the court changes, society changes. And so the court interprets the First Amendment differently. And that creates the challenge for students in this unit. I think the best thing to do is to try and think about how, as a student or as a person, how do I feel about an issue, right? Do I think that there should be an expansion of rights? Should there be a contraction of rights? And then go from there. Think about where your values lie, and think about how to make those arguments to support what you believe to be our important values in American society. I don't know if that makes sense or not.
Professor Moore.
Yeah, it's no secret that Unit 5 is not in my wheelhouse, but I do think it might have been you, David, that pointed out at the very beginning that our obsession with rights has really kind of stifled some of our discourse. And there's a fantastic book. It's an older book now, but it's called The Death of Discourse. And the authors made your argument, David, in a very compelling way, that we're so infatuated with rights that it actually impoverishes our public civic discussion, because everything becomes a legal thing rather than a discourse political thing. And so I think my thoughts about Unit 5 is, yes, the case law is fascinating. There's all kinds of great stories. It's just really an adventure story in many of these cases. But I would urge students to think about that there's a downside to focusing strictly on law and rights. At a very practical level, I think we become disconnected from each other when we're screaming about our rights, overly concerned about.
Professor Williams?
Yeah, I read something, I don't know who to attribute this to, but they said a democracy is Peter drunk and a constitutional democracy is Peter sober. I'm not sure why Peter gets dragged into this at all, but this to me is the unit where we are forced to think about the limits that a majority should have in a democracy. And you brought up at the very beginning, I think it was you, David, and I think Chris and Tim brought up, the flip side of rights is obligations. And we could talk about a lot of obligations we might have as citizens, but one big one is just, how does this action, either private action or government action, how does it affect someone who's not in the majority, right? Thinking about this Kennedy Bremerton case, right, with this coach doing the prayer at the 50-yard line. And the school district argued, right, this is coercion. Kids are gonna feel like they're forced to do this whether they want to or not. And I don't know whether that decision was decided rightly or wrongly, but I think we need to think about that. what it means for the non-Christian team on the football team who doesn't want to go to the 50-yard line and pray, the student who doesn't want to stand up and give the flag salute, right? And I think that's an obligation we have as citizens in a constitutional republic. And I think that's what Unit 5, through the case law, that's the meta point, to have us think through those stories and think about what it would be like to be on the outside.
So yeah, I kind of want to touch on something that Mr. Kavanaugh and I think Mr. Moore said, and that is, I taught this for 16 years, had a little success at it. And when I first started this, Unit 5 was my favorite unit. And I think in the beginning of professional development, I was seen as the Unit 5 guy for a while. And it was actually Professor Moore that talked me off the ledge and brought me back to a more sane world. But one of the things over the years that I've judged is there's a tendency for Unit 5 to become this rapid discussion of as many cases as you can mention. And I don't know, and I honestly don't know, what the truth is on that. You have to know case law, but you can get carried away with that. And that's where I Mr. Kavanaugh is right. You do have to know case law. But Professor Moore's also right that I think as you go through it, you have to be well established in the principles. All right, the fundamental principles of our broader constitutional system is how rights feed into that, and these complexities of classical republicanism and classical liberalism there. But like I said, some of the worst hearings that I've judged, and the kids were great, but it was just this recitation of case, and half the cases I didn't know, and I don't know that law school students would necessarily know all these cases. And I'm pretty sure in my history that some kids made up case names and made up things because they knew the judges wouldn't know that kind of stuff. I don't know. So just keep that in mind. Think about the foundational principles behind rights and the issues that come up in Unit 5. And then, and make sure you know a few key cases. I'm into quality over quantity when it comes to analysis. So we have one more segment. Mr. Kavanaugh wants to push back.
No, I don't. I want to reiterate something that both Tim and you said. I'm not going to hold up the book. It's called Pursuit of Justice. But it's really good because for the students watching this, and when you throw out these case names, they're people's names. For the majority, now, are there test cases? Yeah, like Plessy, right? But there's the story behind these cases. Get to know the people behind the West Virginia v. Barnett, the Gobitis family, the 5 cases rolled into Brown. Get to know this deeper history of the real people, like you, like all of us, like everybody listening to this. Get to know that history as well, because it makes it for a much more compelling argument. Sorry.
All right. In our next and final segment of the summer programs, we'll be looking at, of course, the best unit, according to Professor Williams, Unit 6. We look forward to that discussion. I have no idea what we're going to discuss because Unit 6 is so squishy, I guess would be our term. But we will have fun doing that. So until next week, peace, love, yogurt, tacos. Bye-bye, bye bonds.